Good evening, everyone, and welcome to the 10th annual Georgetown International Arbitration Month. We are about to begin the second panel of this day. This panel is regarding the future of arbitration, and we will be talking about the institutional arbitration in particular. We will focus on the challenges and opportunities that arbitral institutions face in the coming years. Among other interesting topics, today we will discuss about the future of technological advancements in arbitration, including the lessons we have learned from COVID-19. What are the next challenges for the development of international arbitration, and how institutions are constantly adapting to this new dynamic nature of arbitration through new versions of the rules. For this, we have representatives from the world's leading institutions and organizations with us, who will give us their views on these issues. Our first panelist is Luis Martinez. Luis Martinez is the Vice President of the ICDR in the region, including the East Coast of the United States, Central and South America, the Caribbean, Spain, and Portugal. Luis was also the first attorney hired for the newly created ICDR in 1996, also its first director. He is also the honorary president of the Inter-American Commercial Arbitration Commission, and he's a prolific contributor of publications in international arbitration and a frequent speaker at worldwide programs. Second, we had Shiva Filipic, which is the managing counsel of the ICC International Court of Arbitration. Shiva oversees and coordinates the work of the ICC case management teams in Paris, New York, and Hong Kong, and soon also in Sao Paulo and Singapore. She previously acted as a counsel in charge of these case management teams, dealing with cases from the Eastern Mediterranean and the Gulf regions, followed by her work in the Eastern European and North American ICC case management teams. Prior to joining the ICC, she worked as a legal assistant to Professor Martin Hunter at the Essex Court Chambers in London and as a legal counsel in the Bank of Slovenia. Third, we have Kevin Nash with us. Kevin is the registrar of the Singapore International Arbitration Center. He leads the institution's secretariat in the provision of case management services. And over the course of the past decade, he has overseen the administration of thousands of international cases under all versions of the institution's rules and the UNCITRAL arbitration rules. Moreover, Kevin also serves as the statutory taxation authority under the Singapore International Arbitration Act. And last, but definitely not least, Eric Ng is the managing counsel at the Hong Kong International Arbitration Center. Before joining the institution, Eric worked for 5 years as a barrister in Hong Kong, focusing primarily on commercial and construction arbitrations, as well as in general commercial litigation in the region. He has worked as a counsel and as a tribunal secretary in several major arbitrations seated around the world. Today's panel will be moderated by Frederick Lindmark, who is the Arbitration Month co-organizer for the Georgetown International Arbitration Society. Of course, we would like to thank our sponsors for helping us and supporting us with this event. And we would also like to stress out that all the views and opinions that will be expressed today by our panelists are of their own views and do not necessarily represent the views of the institutions they are representing here today. So with this introduction, over to you, Fred.
Thank you very much for the kind introduction, Martin. So this panel is the second panel of the day, and it very much follows the theme of the first panel, which was on greener arbitration, where the panelists highlighted some of the initiatives taken, for instance, in the greener arbitration initiative are, things such as less flying and, more virtual hearings. And as you know, even before COVID happened, we had started to see developments favoring a shift towards more greener arbitration, including, for example, paperless arbitrations. So as you know, COVID also brought with it a widespread acceptance of virtual hearings. So following up on those developments and some of the things that the previous panel highlighted, I was wondering what lessons have arbitral institutions learned from COVID regarding paperless and virtual arbitrations, or greener arbitration, more generally speaking. Shiva, would you like to start off with that?
Sure, as long as I can manage to unmute myself. First of all, thank you very much for inviting me. It's a pleasure to be in the company of such distinguished panelists and to be involved in an event which is on the other side of the globe. So what have we learned from COVID regarding virtual arbitrations? I would say that first of all, we learned that it's possible to have virtual hearings, in many cases also where we would never have imagined it before. Many of you will probably remember the first case, the first ICC case that went from an in-person hearing into a virtual hearing midway. So the witnesses were examined in person, and then the experts were examined on Zoom. It was the biggest Brazilian arbitration. It was quite widely reported in the press, and that was the first success story. We have also cases that confirmed how often actually physical hearings are not really necessary. For example, in this case where we had 88 participants, 28 fact witnesses and expert witnesses, 11 of which were in the hearing center in Paris, but the rest were in remote locations. And I remember when the pandemic started, we were all very cautious, and you heard oftentimes people say, yes, okay, virtual hearings, but not when it's a really complex case and you have to cross-examine people. And fast forward just a few months, and now it's become the new reality that, you know, you have people completely conversant and completely fluent in using, electronically shared documents, electronic cross bundles, talking about text searchability, data integrity and security, nomenclature, use of hyperlinks, and so on. So yeah, we've come a long way since then. I think it was ultimately a confirmation that, as so many times, it's the necessity that drives change. And I think from the point of view of institutions, it was also a moment of true leadership on the part of institutions. ICC in 10 days composed a guidance note by the court's leadership. With the court leadership, the secretariat worked with the court leadership, and we published this practical guidance on what considerations to take into account where deciding on whether or not to hold a virtual hearing, what factors to consider in organizing the virtual hearings. It included even a detailed checklist for virtual hearing protocols and suggested clauses for cyber protocols and procedural orders. And this has now become part of our general guidance note, and is still there after so long, and it has been really produced almost overnight. And finally, and I will conclude there because I've been already way too long, it has really disproved all the concerns about due process that were also quite present at the beginning. We haven't had any award set aside successfully on the basis that the tribunal didn't hold an in-person hearing. I'll conclude there, although, as you can see, I could go on for much longer.
Thank you, Shiva. Absolutely. Louis, do you have any thoughts to share on this?
Sure, and let me just also thank the organizers and Georgetown Law for the invitation. It's a pleasure to join you and to be part of this distinguished panel. Our experiences were very similar. I think the international arbitration world in general, the leading institutions such as those represented here, were quick to transition to using the virtual hearings Our experiences were similar. We immediately put together protocols for the arbitrators, for the parties. There was an initial reluctance, I think, in the larger cases, but remember when we first started out, we thought this was a matter of a few months, and who knew it would go on to 2 years, and hopefully now we're seeing the end of it. But having said that, the initial reluctance quickly disappeared. People became more proficient. The arbitrators became more proficient. They were comfortable with the security measures. I think our experience tended to lean towards people opting for the Zoom platform. And then with that, we proceeded to train a group of people that oversaw these and provide the services related to them. So clearly, they are now part of every day. We have a page on adr.org COVID resources where we have the statistics. And, since March up until February of this year, we've seen 17,000 instances, that includes domestic and international, of course, of virtual hearings and used in 9,000 cases. Now, having said that, now as we're transitioning out, the big question will be, are they here to stay? Is it part of the permanent landscape? And as usual, we're driven from the feedback from our users, and they're telling us quite clearly, because of the obvious savings in travel and costs, and also the fact that they can participate in all the other advantages. Of course, we can discuss the disadvantages, but apparently there is a huge preference to keep this in our toolbox, and I think we'll all continue to do so. I still think, though, that in the larger cases, and I've already seen some requests where parties are switching and looking for either in-person or some sort of hybrid, I think the lack of some of the world's top leading counsel advocates who have the skill set where they need to be in a room and have a feel for the room, have a feel for the arbitrators. It's hard to gauge if you're being effective with presenting the facts or your examination times in this medium. So with that limitation, and it'll probably improve with technology, but I do think for some of the larger cases, there's still going to be people who are going to select and opt for the in-person or a hybrid thereof.
Thank you, Louis. The question you posed are the technologies that we've been using, are they here to stay? I think that's a very good follow-up question. So, Eric, do you think they're here to stay with the HKIC?
Yeah, thanks, Frederick. And again, thanks also to Georgetown for inviting me to participate. I'm very happy to be participating in tonight's or this afternoon's session. As to technology and whether it's here to stay, I think when the pandemic first started in 2020, we sort of had to make a judgment call. It's exactly in respect of this question, because technology is not just something of you turn on, you turn off. You have to make an investment into it. And I think when the pandemic started, we had to essentially, see the future, predict how things were going to turn out, and in many ways take a bet. And we took the bet on the fact that the technology would be here to stay. That's why we invested in virtual hearing technology. We invested in transforming one of HKIC's main hearing rooms into essentially a virtual hearing suite to make sure that we had sufficient screens, sufficient setups, so that arbitrators and parties who are participating from the center have access to make it seem as close to a physical hearing as possible. And that's also why I think HKIC has been investing in both the backbone of our technology in terms of our internal systems, as well as innovating in terms of where we're going to be taking this technology forward in the future. Because virtual hearings, our prediction essentially is that virtual hearings are essentially the first step in a technology transformation. of arbitration. We've talked a lot about greener arbitrations. We've talked about reducing friction and increasing transparency and technology. Now that it's been tested in virtual hearings, is going to start expanding into those other areas as well. So we absolutely, of course, we're very happy that that to date the prediction seems to be correct, but I think that's going to carry forward, and I think that virtual hearings are not only here to stay, that it's going to be basically the first step in a wave of innovation over the next several years.
Thank you. So it sounds like the general consensus is that this is here to stay, and a lot of positivity. So just wondering if does TIAC agree with that? Presumably, TIAC is also quite positive in this respect. What do you think, Kevin?
Thanks, Frederick, and thank you to Georgetown for inviting me. I can finish with a very positive message, because I think that the move to virtual hearings and managing cases electronically has been a very good thing for arbitration. And I think that it's relevant that all 4 institutions represented here today signed a joint statement that we were all going to work together to help manage these cases during the pandemic. And if you look at all of the scholarship that has been produced during COVID-19, so starting, say, I think with the Seoul protocol that was forward-looking, because it was actually released before the pandemic, then followed by ICC, all of the institutions have released guidance. We have a virtual hearing checklist for parties before they go to a virtual hearing, and we've had to adjust, but arbitration really had all of the fundamentals in place. So the difference is, it used to be that you might have a witness of fact or an expert witness, 1 or 2 participating virtually. Now you have completely virtual hearings. And it'll be interesting to see how it is going forward. What we're seeing in Singapore now is people are going back to in-person hearings. And one of the new, procedures is a hybrid hearing. So you could have a situation where you might have both sets of counsel in Singapore, presiding arbitrator in Singapore, and then the co-arbitrators, even if one is in Singapore, both would participate virtually, just so it's the same on each wing. And you could almost ask a provocative question: once we're out of the pandemic, will there ever be a case management conference held in person again? Or will these just be virtual as a matter of course? And yes, there will certainly always be space, and there are going to be counsel, those very complex cases where witness credibility might be key, where you need to see the whites of the witness's eyes. But overall, these virtual hearings, they've actually made arbitration faster, more cost-effective, and greener. It has been, in a very tough situation for the world, it has been a very good thing for arbitration in SIC's experience, and I think that's reflected with all the other institutions.
Thank you, Kevin. And you actually ask a very good question, because some of those who are with us here who are students, maybe we'll never actually see a in-person case management conference in our life. So that's an interesting thought. Another question that I had in mind in the same line is a lot of arbitral institutions have invested in fairly state-of-the-art infrastructure and hearing facilities. And I was just wondering, in terms of investments in real estate, was there any wake-up call or anything that the arbitral institutions learned from this that they could take into the future? Do you think that investments in infrastructure and physical infrastructure and hearing rooms, will that change in the future? We can go to Eric. What do you think?
Yeah, thanks. I think, I just mentioned earlier that we invested in the real estate aspect because HKIAC is a sort of a full service shop, in that we both provide the administration as well as the hearing venue and space. And we invested in infrastructure. We invested in the real estate to make sure that we would have at least one virtual hearing suite that could accommodate major cases in a virtual context. And we have found that that was actually a good investment, because we have used that virtual hearing suite quite a lot since it was launched in September of 2020. And so there is still room for the physical infrastructure. I don't think we are in a situation where the institutions are essentially going to be providing a VR or a fully virtual sort of hearing facility at the moment. So there are still going to be many of these cases that are consolidated towards a hybrid or partially virtual setting, in which case these hearing facilities in these rooms are still going to be very important. But we have invested a lot in terms of both the real estate, the hard fixtures in the room, but also a lot in terms of the soft aspect of technology, making sure that our IT backbone, our IT infrastructure is perfectly in order, investing in making sure everything is secure, because cybersecurity is a paramount concern, I think, for arbitral institutions as well as counsels and arbitrators. And also, I think, which hopefully we'll be talking about later, as well as other aspects down the road in terms of the arbitration process, making document filings greener, making, we just recently launched HKIC Case Connect, which is, where we're sort of seeing that next step in terms of providing a central repository for filings for documents, so that you're no longer having to send, box files and USB sticks across the world, especially in a situation where COVID-19 has shown that the supply chain is extremely vulnerable, and the distribution chain can sometimes be unreliable. So, we have put a lot of investment into infrastructure. Some of that's not going to be apparent. Some of it's going to be quite invisible to users. But it's critical that that infrastructure is there in order for us to provide the services. So I think, this is an investment, and we have HKIC and all the other institutions, I think, have put a lot of work into making sure that that investment is there.
Thank you, Eric. So I would actually like to ask a different type of question as well, because I think that one of the things that we have been seeing recently is, there's been a lot of talk about cryptocurrencies and decentralization. And recently we saw that a major law firm actually purchased a plot of land in a virtual reality world called Decentraland. And, I think that one of the things I'm wondering about is, do you think that the future of arbitration is on the metaverse? Are we going to all sit in our own living rooms wearing VR goggles in 5 years' time? What do you think about the future of those kind of technologies for arbitration? Anyone wants to take this one? I don't want to push anyone to answer this. Might be a bit difficult.
Well, I'll just say that we've all been so responsive to what our users tell us that they need. We've all been investing in our technologies, and as Eric mentioned, we've invested in large conference rooms with state-of-the-art audio-visual connections, and we're monitoring the situations with cybersecurity and always trying to improve our platforms accordingly. So I would say that this field, being so receptive to what our users are looking for, and where there's a possibility for different types of dispute resolution models, I can't say that that wouldn't be a reality down the road. I mean, we're already looking at smart contracts and blockchains and other forms where arbitration and some form of ADR can participate in those types of mechanisms. So it certainly is a possibility.
Thank you. Thank you, Louis. Anyone else want to chime in on that before we move on to compliance? Okay. Well, Shiva, would you like to say something?
I wanted to just bring up what we maybe mentioned before, that I think that Eric had this brilliant observation, and sorry, Eric, but I have to bring it up, of a potential completely decentralized arbitration institution with no somewhere in the metaverse. But what we discussed, what came to mind first when I heard you ask this question is the possibility that enhanced virtual reality or enhanced reality or completely virtual reality will become part of both the procedure. For example, hearings, we can, I think, quite clearly already picture being logged in with some binoculars and participating in via hologram in a hearing or a meeting, and also. I think it's possible to see how tribunals, for example, could project themselves onto a very remote location to, I don't know, conduct a site visit or something like that. So it's a very exciting topic, so many different uses. And these are really the most obvious ones. There is so much that we can't even predict yet, but it will definitely become the new reality. And dispute resolution will be impacted by it.
Thank you, Shiva. Let's move on to a different topic. Since this is a panel about the future of arbitration, we have to try to touch on some other things that are not technology related, as interesting as that is in itself. As you know, in recent years, we've seen a lot of very increased scope of domestic legislation on national security screening, export restrictions, economic sanctions, and cybersecurity and other compliance regimes that not only parties to disputes have to deal with, but also arbitral institutions. So I wanted to ask, how have arbitral institutions dealt with these increasingly complex compliance regimes, and what are the main compliance challenges faced by institutions today? And what challenges do you think might appear in the future? Kevin, would you like to go first on that?
Sure. I mean, it's one of the most important things that an institution does. If you look at it, institutions have millions of dollars that are moving through all of the different cases that are collected in the way of deposits. So you need to have processes and procedures in place to make sure that you have your AML and CFT checks, and sometimes in the case of sanctioned parties, without really any or impact from the institution, the money just may not move. There may be a correspondent bank in the way that makes it difficult for monies to come in or monies to go out. I think that we all still get a great benefit from the ICC, LCIA, SCC note on the administration of disputes involving sanctioned parties. I think that it's generally agreed that the presence of a sanctioned party will not impact on the commencement of the arbitration per se, but there's also a lot more nuance to that as well. Is it just the parties to the arbitration, or is it also the beneficial ownership? What is the level of diligence required by the institution in order to see what the ultimate holding company is, say, in this dispute, or a subsidiary? Are they the subject of sanctions? We're pretty fortunate in Singapore because Singapore does not enforce unilateral sanctions imposed by other countries, but we do enforce the United Nations Security Council resolutions. So we have had disputes involving sanctioned parties. This will involve putting up ethical walls within the institution. You have to be mindful of the governing law of the contract, the nationalities of the case administrators, members of the SIC Court of Arbitration. But these regulatory issues, I think, becoming more and more important for institutions, particularly as you have new emerging countries that are participating more in SIC arbitrations in particular.
Thank you, Kevin. Let's go to Eric. Do you have any thoughts on this?
No, I think I echo almost everything that Kevin has said. I think both SIAC and HKIAC have had similar experiences, both in terms of our administration of cases with sanctioned parties, as well as our response to it. I think HKIAC revised its sanction policy in response to current developments last year. And much along the lines of what Kevin has already mentioned in terms of, making sure that we can still administer the case, as well as making sure that we are putting up adequate safeguards and adequate checks and due diligence. Myself being an American citizen, unfortunately, most of those ethical walls deal with me. So there are a lot of walls up around me in respect to these cases. But to date, we have dealt with cases with sanctioned parties, and we have in most of these cases found ways to administer. Actually, in all of these cases, found ways to administer the arbitration. The biggest issue I think Kevin has also flagged is actually not so much the institution's administration of the arbitration, but it's the banks, it's the money, and it's figuring, finding out ways of making sure that deposits can be paid, that the fees can be paid in relation to these transactions and these considerations. And obviously, we're not there to evade the sanctions, but we do also have an obligation to administer the case.
Thank you, Eric. Well, I wanted to ask, Shiva, I wanted to ask a follow-up question relating to this. So if you could focus a little bit on what do you think the future of compliance regimes look like? Do you think that it'll be vastly different or vastly more complex than what we're looking at today?
Well, I hope for everybody's sake that they don't become vastly more complex, but I fear that they will continue to become more and more complex. The world is a very tricky place right now, and I'm not sure that that's not going to continue. That's the biggest challenge, I would say, is to face this constant fluctuation and just the increased number of different sanctions regimes that apply, and just the vast majority of the information that has to be analyzed by institutions. Because what you need to bear in mind is that every case has to be analyzed on a case-by-case basis. There is unfortunately, no general guidance that we can offer to the parties really as to what to do if you have a case that may be impacted by sanctions. We tried, I think all the institutions, we have the note which explains the applicable regimes, which are different, of course, for the ICC, because it's a French entity, right, subject to French to laws that apply and regulations that apply in France, than, for example, in Singapore. But you can't predict in advance. So I think what the institutions are struggling with, I think the biggest tension is between the need to, the wish to be as transparent and efficient as possible, and at the same time, the fact that it doesn't, most of the time, the impediments, the effects don't really come from the institution. They come, as Eric said, from the banks. It's the network of the banking system is very complex and very prudent, very, very prudent. What is true of ICC, and I'm sure of probably everybody else's institution, is that we work very closely together with the authorities to ensure and to get any clearances, any licenses that are possible. And I think that is one of also big challenges in the future, to continue doing that and hopefully provide a bit more predictability to the parties through that, and also working together with the banks. I know from my personal experience, because I'm not protected by a wall from these issues like Eric is, but the banks right now, the banks with whom ICC operates, understand much better what we do, how we do it, and so the issues are also attenuated by the constant dialogue. And just to conclude on the dialogue issue, I think it's very important to say that it's good for the parties to also be forthcoming with the institution. So, for example, like for certain sanctions, if it's an OFAC sanction or an US embargoed company, we will not apply the US dollar. We will apply another currency. If we receive a filing fee in US dollars, that raises a big flag with the bank, and it's already very difficult to then administer the payments more precisely. So I think that the future is in the increased transparency on all fronts, and hopefully by understanding each other better, it will be easier also to get some more clarity.
Thank you, Shiva. Luis, following up on what she was just mentioning, are there any particular advantages or disadvantages with being a US-based institution in this respect?
Well, we're just in the same scenario, but it being a US corporation, we obviously have to be sensitive to the laws imposed by the United States, and some of those sanctions are US-based sanctions. And so we've had cases where it is difficult for us to handle the financial components of it, the deposits and compensation issues. We look to OFAC licenses, and we look to the parties and the arbitrators to clarify these issues and see what can be or cannot be done. We will with any laws that we're required to follow in this jurisdiction. And in addition to sanctions and related issues, there's also other legislations that impact our administration, and I'm sure our colleagues to a certain extent. Things like the GDPR, we have an extensive amount of personal data, identifiable data that may be transferred in the process of an international arbitration. So much of it, in fact, could be falling into those categories. And as you know, the GDPR, when applicable, applies to the transfer, and that it has to be done with adequate cybersecurity, which is why we've all undertaken so many intense initiatives on the cybersecurity front. When we initiate the case, we send out a checklist, we send out best practices, we remind the arbitrators this is an issue if the GDPR is in play, or any other data regulation. This is something that needs to be discussed and sorted out with the parties to ensure that there's compliance. You don't want to leave this till the end and run afoul of these particular issues. As you know, the GDPR has the potential for some very extensive penalties. So we also internally, based on the security protocols, our IS department has put together extensive programs monitoring the technologies in place. We have various electronic administrative platforms, one for the parties' web file, one for the arbitrators' e-neutral center, and then, of course, at the core of it is what I and my colleagues use to administer the case. Everything is electronic. Everything is done. There's just no need for the paper trails. Everything is uploaded. Everything is tracked. The computer, once it's aware of the applicable rules, tracks the time frames, sends warnings when things are not where they need to be. You can upload invoices for the arbitrators, and you can administer these cases virtually from anywhere in the world, which is why for international arbitration and domestic in our case as well, transitioning to the remote was not a problem. But we have to be aware of situations like the application of the GDPR, make sure you've got all the appropriate safeguards, make sure it's dealt with. And it's just another layer that, well, it's part of our administrative challenges and things that we have to be aware of so we don't run afoul and get into trouble down the road.
Thank you so much, Luis. And before I want to have a couple of minutes to ask some career-related questions. But before we do that, besides the regulatory challenges and the technological challenges and opportunities that we've already discussed, are there any pressing opportunities or challenges that international arbitral institutions, such as the ones that you work with, any challenges or opportunities that they will face in the coming years that you can think of that are pressing and important? So up for grabs for anyone who wants to chime in on this one.
Is the question related to challenges that students will find?
No, sorry. Do you think there are any things besides technology and regulatory challenges that institutions will face, which we haven't discussed so far?
Well, again, I think, and we're all similarly situated, institutions are now being asked to take a hard look at issues such as diversity. This is one of the things that we've been looking at. A few years back, there was the move to look at gender diversity, and now I think it's been expanded to racial, sexual orientation, disabilities, and these are all part of the ESG considerations that I think we're all going to have to be looking at. We are guided by our ESG platform is the work of the World Economic Forum. We're looking at their particular standards and metrics involving things like climate change, diversity, and related issues. And I think this is going to be part of the future growth and plans of institutions such as ours that operate in cross-border transactions, the greener arbitrations that your previous panel discussed. So it presents a whole new landscape for us to be sensitive to. And as we consider our rules, our administrative processes, and the environmental and social impact, these things go hand in hand, and we need to make sure we're understanding it and acting accordingly.
Absolutely. Thank you. Okay, I would like to ask a couple of career-related questions before we hand the floor over to the audience to ask questions. But first of all, I wanted to ask if for a young arbitration lawyer, who there might be quite a few in the audience, and who might be coming fresh out of law school, what advice can you give them? And what was it that made you choose to work at an institution to follow this track? Kevin?
Yeah, that's a great question. I've told this story a few times, and hopefully no one's heard it before. When I was after I came out of my LLM and I was deciding whether to go back to practice or go to an institution, a very well-known arbitration counsel said to me, the question is, do you want to be successful or do you want to be good? If you want to be good, go to an institution. You will become a master of procedure. Then you can circle back to practice thereafter. I think his advice probably wouldn't have been to stay 10 years like I did at an institution, but maybe I just like procedure that much. What I would say to any student is that what there is in arbitration now is there's a lot of different ways to do it. So there's no set path for becoming successful in arbitration. You can work for an institution. There's value being in litigation, arbitration practice, tribunal secretary work. There are many ways to do it, and you have to realize how long your career in arbitration is. One of the things that I find very fun about arbitration, our most senior eminent practitioners are still learning, still have a curiosity. There's a kinship in arbitration that I think, because lots of us, or at least me, feel that we had to get a few lucky breaks to get to where we are. So it seems like arbitration, compared to some other practice groups, everyone is very willing to help out. So I think as a student or a recent graduate, you can reach out to some of the luminaries in the field, and I think you'd be quite surprised that they will probably get back to you.
Thank you so much. That's very reassuring and encouraging. Eric, do you have any thoughts on this?
Yeah, I think maybe I echo what Kevin was saying, is like being at an institution really sort of puts your head in a space of understanding the procedure a lot more. And one of the reasons why I joined HKIAC, because I was a practicing barrister in Hong Kong at the time, was as a counsel you're maybe dealing with 1, 2, 3 arbitrations a year. I mean, most of the work that you'd be doing would be, in court, in litigation and stuff, but you'd be doing some arbitrations. If you're very, well sought after in arbitration, you're maybe dealing with, 5 or 6 a year, maybe some major cases and stuff like that. If you're really, really popular, looking at a dozen a year. At HKIC, or I'm sure all the other institutions, as a counsel, and especially as managing counsel, I have at any specific point about 200 to 300 arbitrations on my plate. That's dealing with, approximately, 200 to 300, sets of counsel, all of whom are, spending every waking moment trying to break your rules, trying to find loopholes, trying to find ways of getting that extra day or 2 days out of a deadline, or finding, how do I break this appointment procedure? How do I, do this list procedure in a way that advantages my client? So you suddenly go from, a micro view where you're really looking at one case and focusing on one case, to having to take a much more macroscopic view and seeing sort of how procedure is not only being used, but and understanding the use of and the operation of that procedure, but also seeing sort of the trends, seeing the growth and the evolution of arbitration, and you're sort of seeing it in real time. I think this was clearly apparent during the pandemic, where you see, counsels at first, resisting virtual hearings, to accepting virtual, that they had to do virtual hearings, but then, objecting to other actual procedural aspects of it, to now sort of we're seeing even those sort of procedural objections fading away. And you see sort of on a macroscopic view how counsels are adapting, and how firms are adapting to changing conditions in arbitration, which means that when you go back, or if you decide to switch to, being at a firm, to being a counsel, to being an advocate, you suddenly have a much broader knowledge of, how that procedure works, and what other counsels are thinking, and what you've seen at an institution is, effective or not effective.
Great, thank you. Shiva, do you have any thoughts on this? And I also wanted to just add a small follow-up as well. Do you think that networking is as important in if you want to get a job in an institution as it is if you wanted to do counsel work?
So I completely concur with what Kevin and Eric said, and maybe I would just add that you learn from the best and you learn from the worst. Not many times you learn from the worst when you go into a major law firm, right? There is this huge difference in, okay, you see things on a much more shallow level, but the breadth of experience, I still remember the first day when I started as the managing counsel, which was already after 5 years at the ICC. And the first day when I started, I got a phone call from one of the really leading arbitrators, and he said, "Jiva, I have never seen this before." And I said, "But if you haven't seen it, what do you think that I have?" And he's like, "Yes, I think you have a much better chances that you have seen something similar. I'm sure you haven't seen something like this, but exactly like this, but something similar." And it was true. We brainstormed together, and I was shocked at myself and immensely proud of myself that I was even able to hold the conversation with somebody of such incomparably vast experience to mine, that I gained in just 5 years, so to say. Is networking important? I think it is. I think it's always important. It pains me a bit to say it in these days, because I think that that's one thing that the students or the junior practitioners these days, they do suffer from in the virtual hearings. It's not the same. The networking opportunities, we have one later, but it's simply not. It's not the same. You can't just fall into a conversation with somebody and stay there for 2 hours and continue in a restaurant afterwards, right? But yes, I think it is important, but it's important also because it's good to have views from people. I mean, it's good to get them from panels like this, but in a one-to-one conversation, you will really get a feeling of what would suit you. Ultimately, I agree with Kevin. It doesn't really matter whether you start as in a counsel at a law firm or at an institution or in-house, but I think with networking, you also get a much better feeling of what resonates with you more than perhaps another thing.
Thank you very much. We have time for one last thought. The last person here. So Louis, do you have any thoughts about this? Any specific advice you can give to young practitioners?
Well, I would say, and I am a proponent, I think networking is important. And for example, I oversee our ICDR Young and International group. We have 3,000 members in over 90 countries. You can join for free. There's extensive free programming available. You go to the icdr.org site under Education and Resources, and there you find the Young and International page. There's over 60 recorded programs there. And a lot of the programs, too, deal with how to develop your career. We focus on messaging for young people entering the field, establishing yourself as a young construction arbitrator, or advocacy skills, cross-examination of witnesses, you name it. There's just a ton of information there. I do think, though, there was an advantage because of the extensive programming, more programming done virtually during the pandemic. But the in-person ones, I think, were very useful. We're going to be doing some in New York. We have an upcoming program in Switzerland in person, where you get to meet people face-to-face, meet the people from the institution. And that is helpful. I think relationships, knowing what's happening in the local cities and opportunities that may arise, I think are also very important. This is a people business, as was previously mentioned, and I think seeing eye to eye and getting to interact is also valuable.
With that, I think we have run out of time for the panel. So I would like to thank you all so much for coming. We will have some questions first, and then we will have breakout rooms. But I would like to once again thank you all so much for coming, especially those most of you. It's very late, I know, and it was very generous of you to still come and help us make this happen, so we can have a very much global debate about the future of arbitral institutions. Once again, I would like to thank our sponsors. If it's possible, could we bring it up on the screen, the sponsors and the supporting organizations? I would like to thank the sponsors and the supporting organizations for having shared our events and for having made this possible. Without them, it would not have been possible to do that. Here we are. That's our sponsors and supporting organizations. Thank you again.